I'm gonna never do like this, so I know your friends don't like my plea, but you for no say this kind thing be this. So let me know if you know what to do again. I know go disturb you, I know go stress you. Yeah. Let me know if you know what to do again. I know go disturb you, I know go stress you, but don't call me back, oh. Don't call me back. When you see say I don't there with another kid, baby, don't call me back, oh. Don't call me back. When you see say I there with another kid, baby, don't call me back. Even if you call it, no go connect, cause I know go there. I know the way you make you forget. Come another day. Even if you call it, no go connect, cause I know go there. I know the way yeah. She say you need some space. I give you 6 months of grace. That girl you see last night, never mind to take your place. I even let you know who be who, but she ready more than you who. So if I get which kind of level it is, yo. Let me know if you know what to do again. I don't go disturb you, I don't go stress you. Let me know if you know what to do again. I don't go disturb you, I don't go stress you, but don't call me back, oh. Don't call me back. When you see say I know there with another kid, baby, don't call me back, oh. I'm not coming back. When you see say I there with another kid, baby, don't call me back. If I give you love, my head don't go there. I say if I give you love, my head don't go there.
Is back. Shop your favorite brands at the best prices. Laptops.
Hello guys, can you guys hear me? Can you guys hear me? Please, if you can hear me, put it in the chat box that you can. Hello guys. If you can hear me, please put it in the okay, very good. I just saw one I can, so I'll be starting soon. I'll be starting very soon. Let me put the whole thing. I'm a king. I'm a never see. I never see it.
I never miss. I've been smashing, I've been killing everything. From the age of the old you will never reach. To the many places that I've never been. Remember this, I'm a king. I'm a legend and a legend, I'm a champion.
Okay, so can we start now?
Remember this, I'm a king.
I'm a legend and a legend, I'm a champion.
Remember this, I'm a king. I'm a legend and a legend, I'm a
Can we start now, guys? Hey.
see what you carry. No more in the money. Make a money gonna give it to me sharply. Don't say mommy, buy that mommy. I could do this all night long. Don't baby, carry me the go.
Okay then, so it's time to start. I think I waited about 10 minutes for people to get back here, but I guess I'll just start anyway. So how are you guys? Good afternoon, happy Sunday. How are you guys? I want you guys to write in the comment section how you are. I think only two people are online right now. So write in the comment section how you are before we continue. I'm trying to know whether or not you can hear me and you are following the class. Hello? Can you hear me? Oh, okay. So moving on. So today we'll be talking about equity will not suffer a wrong without a remedy. Oh yeah, I'm fine. Thank you very much, Hikma. So today we'll be talking about equity will not suffer a wrong without a remedy. And then the question is, what does that mean? Do you understand? That's the first maxim that we have. Equity will not suffer a wrong without a remedy. The second maxim is equity follows the law. The third maxim, where equity is equates, the law shall prevail. The fourth maxim, where equity equates as well, the first in time shall prevail. And then after that, we have he who seeks equity must do equity, and then the rest. But today we are talking about the first one, which is equity will not suffer a wrong without a remedy. Now, for you to understand that particular maxim, you need to understand how equity started in the first place. Do you guys understand? For you to understand the maxim of equity will not suffer a wrong without a remedy, you need to understand how equity started in the first place. And I think I tried to explain that in a particular live session video where I spoke about the history of equity. Do you understand? But today I will just do a brief rundown of the history and then talk about the original jurisdiction and the concurrent. Hello guys, are you following me? Please put it in the comment section so I will know that you are following. Equity. Equity will not suffer wrong with that remedy. So guys, okay, good. Hikma said I'm following. Okay, good. So let us move on then. So now, when we are talking about the history of equity, we need to understand certain things. You know that when you're talking about the history of equity, you are talking about the common law. Equity came as a result of the harshness of the common law. See, you know that when you are answering past questions for equity, especially for University of Lagos. Number one, the reason I hammer on history of equity as well as the maxim when I'm teaching equity is because number one is usually history and maxims. Either history or maxims or a little bit of both. Do you understand? So once you understand the history of equity and you understand the maxim of equity, the maxims that we have, you've gotten at least 15 in your number one. Do you understand? Once you understand it very well, and it is usually not problem question, it's just essay. They just want you to come, just go and write everything you know about the history and the maxim. Do you understand? So once you can get to the exam hall and table down history and number one and two of maxim, then you are good to go for 15 marks. Do you understand that? Then number two is usually ranking equitable. Do you understand? Number two is usually when they tell you to rank equitable interest and they tell you to rank the legal interest. Do you understand? But number one is usually history. So why not concentrate on one thing that you know that you can get as much as 15 marks from your exam without having to break a sweat? Unlike number two, you know when they say you should you should prioritize the legal interest and then the equitable interest. You know what that means. You know that you have to sit down, you have to look at each of the interests, how they were created, did they have notice over the other, and if one had notice, then that can't be prioritized. Do you understand? So you see, it is usually very easy to answer number one than to answer the rest of the what's it called, the rest of the um, answers. That's the rest of the questions, rather. So when you are talking about number one, there are certain things that you must put down when you're answering number one, and that is history. Today we are talking about this maxim, but this maxim cannot be spoken about without we talking about a little bit, at least, of history. Do you understand? This maxim cannot be spoken about. So now, when we are talking about equity will not suffer a wrong without a remedy, what do we mean? The first place we have to start from is the original jurisdiction of equity. Are you guys following? The original jurisdiction of equity. The first place we have to start from is the original jurisdiction. Hope you guys are with me. Hope you are with me. I'm just trying to be sure. So the first place we have to start from is the original jurisdiction of equity. And what do we mean by the original jurisdiction? Do you understand? Now, when you're talking about the original jurisdiction of equity, we have to look at things like trust. As an example, trust. Do you understand? We have to look at things like trust. So let us start with trust. What is a trust? I'm very sure that you guys must have they must have taught you guys. I'm very sure they must have taught you guys what a trust is. A trust is when you have three parties. You have A, you have B, and you have C. Do you understand? The first one, okay, yes, I'm with you. Okay, good. Oh God. Okay, are you guys with me now? Write it down that you're here. I'll just continue regardless. So I was telling you about trust, and I told you that when you are talking about trust, you have three very important people. You have the trustee, you have the testator, the trustee, and you have the beneficiary. So who is the testator? Okay, so as we are back, I think the network was just trying to play some tricks. So if you are here, please, can you please tell me if you are here? Write it down that you are here, because I don't know. Network is behaving like what I don't know here. Are you guys here? Hello? If you are here, please write it down before I continue, because I'm about to continue now. So I guess I was talking about the trust. Can you guys hear me? Okay, I'll continue regardless. So I was talking about the trust, and then I said that when you are talking about the original jurisdiction of the court, you have to, that's the original jurisdiction of equity. There are certain things that you have to note. Do you understand? When you're talking about the original jurisdiction of equity, so yeah, somebody told me that she's here. Okay, no problem. When you're talking about the original jurisdiction of equity, there are certain things that you have to note. What are those things? The number one is the trust. Do you understand? Now, under the common law, yeah, uh, okay, so under the common law, you have the testator, the trustee, and then the beneficiary. You know, when you are talking about the common law used to be harsh. I'm very sure a lot of you know that already. So when you're talking about the original jurisdiction of equity, equity helped to mitigate the harshness of the common law. That is the essence of equity. That is the reason equity came about. If you are studying the history of common law, then you would, the history of equity rather, then you would know certain things about equity. Number one, when we're talking about we only had the common law court, we had nothing called chancery court. The chancery court is the court of equity where equity evolved from. Due to the harshness of the common law, people started taking their cases, instead of them to take them to the common law, they started taking it to the king. And then the king then delegated his duty to the Lord Chancellors. The Lord Chancellors were the ones that was administering administering justice. According to them, justice was by conscience, by fairness and 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 good conscience. Do you understand? So, according to John Seldon said administered justice according to the letter of his foot. Do you understand? That is usually a question. That's number one question in what's it called, in past questions. Most times exam questions by Professor Oni. When you are reading number one, there are certain things that you are supposed to know. There are three cases that are also very important. You have the case of Neath versus Rydley. You have the case of the Earl of Oxford case and Glanvil's case. I can't remember the other one. Glanvil versus something. I can't remember the other one. Those cases are very, very important when you are talking about the history of equity. So when you're talking about the original jurisdiction is where did equity, what were the things that equity had to do to mitigate the harshness of the common law? Then you are talking about the original jurisdiction of equity. Do you understand? So equity will not suffer a wrong without a remedy. In relation to trust, like I was explaining earlier, I told you that there was something called the trustee, there was something called the testator, and then we had the beneficiary. So who was the testator? The testator is the person, the owner of the property. Do you understand? The testator is the person who owns the property, and then the testator is giving that property to the beneficiary. So let us say that the testator here is a father, and a father is giving an estate worth 50 million naira. Estate means a property, a building, whatever it is giving an estate worth 50 million naira to the beneficiary. The beneficiary here being his son. But his son is just 2 years old as at the time he made the will, and then the father died when the son was 5. Now, it's very impossible for the son to hold the property because he's just 5 years old. He doesn't even know what ABC is yet. So then the law would have to give this property to a trustee. The trustee might have been elected by the father in his will. Do you understand? The father could have said in his will that I want you to give this property to the trustee. I want you to give this property to the trustee to hold it in trust for my child when my child eventually grows up. Do you understand? So this trustee will have to hold this property for the next 13 years because that is when the boy will be 18 years of age. Do you understand? So until the boy is 18 years of age, the property will be vested in the trustee. Now, when you are starting with the common law was so harsh and rigid that the legal interest on the property was vested in the trustee and not the beneficiary. The legal interest was vested in the trustee. Therefore, most of the trustees, because they know that they have legal interest and they know that the beneficiary, as at the time the common law court was evolving, the beneficiary did not have any interest at all. It was via the chancery court, that is the court of equity, that we now had the equitable interest clothed on the beneficiary. Before that time, equitable interest, there was nothing like equitable. Before the chancery court decided to clothe the beneficiary with the equitable interest, there was nothing like that. All you had was legal interest, and the trustee was the one who had anyhow without any consequences whatsoever. Do you understand? So when you're saying equity will not suffer a wrong without a remedy, we are taking it, we are bringing it to something like this. The beneficiary here is always suffering a wrong, and there is no remedy in court. Do you understand? Because according to the common law court, they did not have a right. But according to the court of chancery, they have a right, and their right is equitable interest. And because they've been clothed with equitable interest, the legal interest, who is the trustee, can no longer act anyhow he wants to with the property anymore. Do you guys understand what I'm saying? I hope you guys are following the class. Now, I just explained to you the part of equity and the legal interest in relation to the trustee, and I was trying to explain to you that equity will not suffer a wrong without a remedy. Do you guys understand? And then we also have other things. We have, you know, when you are talking about the history of equity and the reason equity evolved, for example, now you'll be saying things like uh, um, okay, let us go to the concurrent jurisdiction. I will explain what I want to explain later. Let's go to the concurrent jurisdiction. Concurrent jurisdiction. Now, when you're talking about the concurrent jurisdiction of equity, when you're talking about the concurrent jurisdiction of equity, basically we are talking about what's it called? Where there is what is it? Remedy, yes. Where there is remedy at the common law court, but those remedy are not sufficient enough. If those remedy are not sufficient enough, then the court of equity gives new remedy. Do you understand? So, for example, under the common law court, what we had in those, for example, you have a case of nuisance. Somebody is making noise. You are living beside somebody who likes blasting music, even up to about 3 a.m. in the morning, and it stops you from sleeping, it stops you from reading, it stops you from doing a lot of things that you want to do. You can go to the court and get remedy, but the only remedy that the common law court will give to you would be damages. So all it will give to you, okay, pay him for disturbing his sleep, but there are certain things that I want from the court that the court will not be able to give to me. For example, I want him to stop that particular thing that he's doing. So, according to the court of equity, in order for me to be able to tell him to stop what he's doing, I can ask for an order of specific performance. Do you understand? So, under the concurrent jurisdiction of equity, concurrent means that where you have common law, you also have equitable jurisdiction. Do you understand? When you're talking about original jurisdiction, common law did not exist on something like that. For example, when you clothe the beneficiary here with what is it called, with equitable interest, when you quote the there was nothing like that under common law interest whatsoever. So when you're talking about the jurisdiction of the equity court of equity, when you're talking about the original jurisdiction of the court of equity, we are talking about that place where the common law did not have any jurisdiction whatsoever. Do you guys understand? But when you are talking about the concurrent jurisdiction, then you are saying that the common law had powers there. However, those powers were not good enough, and that's why we have the equitable. It's not like they were not good enough, but they don't fit into every circumstance. Do you guys understand? They don't fit in. It's not every time that what I need is damages. Do you understand? There are sometimes I just want this person to stop this thing. There are sometimes I just want this person to do a particular act. Do you understand? So not every time that what I need would be damages. Do you guys understand? So, well, I've been able to explain the concurrent jurisdiction, and I've also been able to explain the original jurisdiction of the common law of the court of equity, and I hope you guys understand. If you are following, please write it in the comment box that you are following before I move on with the class, because I want to go to a little bit of history, then relate it to this, and then end the class. If you are following, please put it in the comment section below that you are following. Okay, good. Someone said I'm following, so I guess that suffices. So yes, when you're talking about the common law, the history of equity now, when you're talking about the history of equity now, I already, like I said earlier, I made a video on it. This is the last time I'm going to be teaching history in this class. It's a very good thing that you're in the class. This is the last time I'm going to be teaching history. So now, when you're talking about the history of equity, there are 4 things that you have to know. You have to know about the Lord Chancellors, you have to know about the common law court, you have to know about the king, and you have to know about let me write it down so I don't forget. The chancellors, the chancellors, the king, the common law, courts. Do you understand? So when you're talking about common law courts, for example, when you're talking about the common law court used to administer very harsh rules. Do you understand? They administer very harsh rules. For example, that of the trustee and the beneficiary here. The trustee here is excluded with legal interest, which meaning that the trustee can do anything that he wants to do with the property. Now, according to, and that's not the only thing. We are talking about equity of redemption as well. Now, when you mortgage your property, for example, so hello guys, are you still here? I don't know what's wrong with my network, it's just not going well. Are you guys still here? Are you guys still following me? Please, if you're still following me, just put it in the comment section that you're still following me. Hello guys, please put it in the comment section so I'll know. Okay. I can't remember where I stopped. Can someone please tell me where I stopped? I totally cannot remember where I stopped right now. Can someone please remind me? I'm trying to put my phone on the tripod. Can someone please remind me where I stopped when I was teaching? Or should I just end the class? Because I don't know why the network is just misbehaving. So I guess I should just end the class. Okay then, since I'm not getting any response, I guess I'll just end the class right now. So if you have any question, you can just ask me personally.